for both public and private companies, fiduciary duty responsibilities apply. That's regardless of what type of board you're on. And that's where the differences separate. Public company boards are more complex and less complicated because it's totally spelled out. There are SEC requirements, there's good government requirements.
Just quickly on that point, I currently am the chairman of the board of a startup company that's in its ramp phase. But we have a 4-person board, one of whom is the CEO and co-founder, but the other 3 of us take it extremely seriously.
Is intended as a checks and balances in all aspects of the company's operations. And and that's why the board of directors is ultimately responsible if they fail to be diligent in their oversight duties. But I'll provide a bit more detail. The board
keenly aware of the process. We were keenly aware of the importance of minutes. We were certain at some point we might get sued because one of the transactions was to a related party. So we were totally in control of the process, and the point is,
liaison. One person does not a committee make, and that's typically frowned upon. So in my experience, typically 3 people is a minimum number that you would have on committees. Some of ours have 4 on them. When you start getting bigger than that, the practical reality of it is it starts to mirror the board in terms of size and scope often.
Folks in your network who are also aspiring and doing what you can to help make them better, and they will in turn do the same for you as you start to compete together for the visibility that you want and need in order to
But eventually they would hear about some fraud allegation. The more allegations, the more people involved, the more they would hear it. So what it does at this point is it puts the issue squarely in front of the company's lawyer, and they can then determine, he or she, whether to proceed with something.
Whenever I would take one side or the other, they would get angry at me, or somebody would shut down and not talk. So I was completely lost, and I would try all the different ways of understanding the drama that was happening, like, for example, they didn't have maybe communications.
Becomes extremely important in these discussions. So, for example, going back to Kodak actually owned the patents for digital photography, but their culture was one where they weren't willing to give up the phone business to capitalize.
If I were, this would be this would be a crisis that I would purposely exclude the CEO from. Because the CEO leads the organization, and if I'm being paid a visit by a federal law enforcement, I do not want the CEO there. I want to understand.
Yeah, that's what I've seen too. And usually the reason not to invite is it's a cost thing. Yeah. And if it's, if everything's although sometimes you don't know until you've got hindsight to work with, but if it's fairly.
I think there is clearly an element of performance that is based on whatever you've determined is most important regarding the quantitative measurements for the health of
communication was working, because that's something that companies that have the resources should be doing, but not everybody does. And sometimes there are different interpretations, but I do see it as the ability to foresee some of these things. If you're going to get a search warrant, which is obviously a potentially troublesome one.
Make sure you have adequate D&O insurance. That's very, very important for those who haven't revisited their D&O policy in quite some time. It's probably a good thing to see if that coverage is adequate. And your insurance broker can help you with that conversation.
Slide 11 does a good job of laying it out. Let's talk about basic nomenclature first. So in the terms of the owners, right? So there's multiple levels of owners and management and everything else. The owners in the context of a corporation are called shareholders. In the context of an LLC,
the insured versus insured exclusion, which precludes claims brought by one insured against another. Often these days amended so it's an entity versus insured exclusion, so that it only applies to claims by the company against the executives. There are many carve-outs that cross claims are not excluded, derivative claims are not.